Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. This week was a podcast dream turned nightmare. No cases published in the beginning of the week, and then in the middle of the week, turning into no cases published at all this week. What is a lowly podcaster with sponsors and legions of loyal Monday commuters to do? Not to fear. I have an entire folder of immigration-adjacent cases just waiting in the wings to do when such a crisis hits. Preparation is key in the world of legal podcasting. So please enjoy these 3 interesting cases. Lord knows I learned something, and I gained a few arguments in the process. Kicking it off then, with Tereshchenko v. Karimi, published by the Second Circuit on May 16th, 2024. This is another Hague Convention child abduction case. I'm doing it in part because of the good feedback I got last time I did one of these, in part because they interest me and who knows, maybe I'll try to do another practice area, and in part because, well, returning children to Ukraine right now? Come on, let's begin. Miss Karimi is from Ukraine and lives in New York. Her ex-husband, Mr. Tereshchenko, is also from Ukraine. He brought a claim under the Hague Convention on the civil aspects of international child abduction for the return of the couple's 2 children to him from Miss Karimi in New York. One of those children was born in Ukraine in 2016, and the other was actually born in Hollywood, Florida in 2017. The couple divorced in November 2018, and Miss Karimi began to travel. Seems like Miss Karimi initially had primary custody in Odessa, and Mr. Tereshchenko travels as well a lot for work, mainly to Dubai, and the couple kind of agreed on this arrangement. Nevertheless, for reasons a bit unexplained, the children began residing with Mr. Tereshchenko in June 2020. It appears that Miss Karimi was getting a master's degree in London, and so they changed up the arrangement a bit. And then the couple began arguing about custody and the residence arrangement, with Mr. Tereshchenko succeeding on his claim before an Odessa agency. But while undergoing a medical treatment abroad, Miss Karimi came and took the children. Seems like she stayed in Ukraine with them initially. Mr. Tereshchenko filed an abduction report, and Miss Karimi and the children were put on a local wanted list. That's November 2021. And then in February 2022, Russia full-on invaded Ukraine. Isn't life insane? Miss Karimi contacted Mr. Tereshchenko, who by this time is in Dubai, and asked for the passports of the children so she could get them the heck out of Ukraine. And to his credit, he agreed. But under the condition that she bring them to Dubai. Remember, by this point, Mr. Tereshchenko has the residency order from the Odessa agency that is in charge of such things. Having received the passport, Miss Karimi instead brought the children to the United States, pursuant to the Ukraine parole program, although I guess one of them is a U.S. citizen, right? Not knowing at all where his children were, Mr. Tereshchenko began a worldwide search, even bringing in Interpol Yellow Notice. New to me. I usually operate in the disreputable world of red and blue notices. Apparently, a yellow notice is used for such things with children. Mr. Tereshchenko himself moved to France in May 2022, and he eventually tracked down his children and Miss Karimi in Manhattan with the assistance of U.S. authorities. He filed this Hague suit for the return of his children, as is his pretty extraordinary right under U.S. treaty law. In the meantime, a Ukrainian court granted residence of the children to Mr. Tereshchenko. I guess the family courts are still operating, notwithstanding the full-on invasion and Ukraine's fight for its life against Russia. Reading the facts of this case, and at least how it's written, it seems that even Miss Karimi thinks that her husband has most of the facts on his side. Miss Karimi made 3 arguments against him in opposition to his Hague Act challenge, though. 1, under Article 13A of that convention, that Mr. Tereshchenko consented to the children's removal and her retention of them. 2, under Article 13B, that the children's return to Ukraine would pose a grave risk of harm to the children or otherwise place them in an intolerable situation. And 3, under Article 20, that their return would not be permitted by the fundamental principles of the United States relating to the protection of human rights and fundamental freedoms. All standards from the Hague Convention that is governing this dispute. Now that first one is factual, but yeah, hard to argue against number 2 and number 3 right now, right? Putting the children back in Ukraine during a war. The district court ruled for Mr. Tereshchenko and, thankfully, ordered the children returned to him in France, and not Ukraine. The Second Circuit technically remanded, but really it affirmed. If you haven't already gathered, it's an interesting case. After all, the Hague Act's, quote, core premise is that the interests of children in matters relating to their custody are best served when custody decisions are made in the child's country of habitual residence, end quote. Which probably often is going to favor return of the children brought to the United States, right? But in this case, that country is in an active, horrific war. To win, Mr. Tereshchenko first needs to show that his children were wrongfully removed or retained. Again, Ms. Karimi argued that he couldn't meet that because he consented, which actually to Ms. Karimi meant that he lacked jurisdiction to even bring this case in the first place. But, quote, as should be apparent, end quote, that's not a jurisdictional argument. That's an elemental argument. Still, though, Mr. Tereshchenko did consent, right? So not wrongful taking by Ms. Karimi? Well, quote, the mere fact that Mr. Tereshchenko consented to the children's removal from Ukraine in the emergency of the Russian invasion does not mean that he failed to prove his prima facie case of wrongful retention. Nor does it mean that Ms. Karimi has established a consent or acquiescence defense under Article 13A, end quote. Plus, and this is just me, so maybe it's not relevant, but his consent was tethered to them going to Dubai, right? Interesting wrinkle. Things get a bit trickier when Hague Act cases are brought over a year after the children's removal. Under such circumstances, the removing parent can show that the kids are now settled, and so that they should not be returned. I recall that was an issue in the Venezuela case that we discussed in episode 210. And it seems that this case might have been brought over a year after the children came to New York. But Ms. Karimi didn't raise this affirmative defense of resettlement until way after her answer and pretty late in the game, and so, well, the courts deemed the affirmative defense waived. That is, of the children being firmly settled in New York. Tough stuff, but law is tough stuff. Now, it appears that as a precursor to ordering the children sent to France, the district court had to find, or at least did find here, that there was no grave risk to the children being sent to Western Ukraine, even though the court was actually going to send them to France. The Second Circuit isn't so hot on that finding, if for no other reason that things have changed a bit since even the beginning of the invasion, and even Mr. Tereshchenko conceded at oral argument that everywhere in Ukraine is now dangerous. But that error of the district court didn't require a reversal because the Hague Convention permits temporary third country return outside the country of habitual residence in rare circumstances. And the largest European land war since World War II qualified to the Second Circuit. Still getting a remand, though, because, quote, the district court's order returning the children to Mr. Tereshchenko in France must be tailored to secure the continued authority of the Ukrainian courts over the children and over the parents' respective custody rights, end quote. Again, really, really rare to not order a child returned to their country of last habitual residence under the Hague Act, but these are rare times, explained the court. And Ms. Karimi is in the wrong, it seems, to the Second Circuit, legally speaking. They're not going to let her out of it because, technically, Russia invaded, making Ukraine pretty horrific to return to. Quote, we see no reason why the convention would categorically bar district courts from an ameliorative measure ordering a child to temporarily reside in a third country to mitigate a grave risk of harm in the state of habitual residence, end quote. Just can't be a permanent order of third country relocation. France is a fine middle ground, reasoned the Second Circuit. Quote, it avoids the grave risk of harm that the children would face if returned to Western Ukraine. As mentioned above, the order seems to us particularly appropriate in this case, where one of the children is a U.S. citizen and subject to the Department of State's advisory against travel to Ukraine, end quote. Nice little touch. Plus the cuisine of France promotes other goals of the Hague Act, too. Again, got to tailor it a bit on remand because a district court, it seems, can't grant a parent permanent custody in a country that wasn't the child's last habitual residence. And that's effectively what the Second Circuit saw as the district court as having done here. So it's a remand, but really, Mr. Tereshchenko won. And the children will be going to France. And that is Tereshchenko v. Karimi. Next up is United States v. Verdugo, published in the Southern District of California way back in 2023. This case is about controlled substance offenses, specifically methamphetamine. And well, if I'm reaching back to a 2023 district court decision, you know it must be special. It is. And it's short. 2 giant positive factors for extraneous pod summary on a short week. The issue here was whether a California conviction for transportation and possession of methamphetamine for sale matched the federal definition of a controlled substance offense such that U.S. citizen Mr. Verdugo should have his supervised release revoked. It does not. Because according to one district court judge in San Diego, admittingly, California's meth definition is broader than the federal generic definition of meth. And well, as always on the podcast, that's a very big deal. Bigger when a circuit says it, but here's your case to argue throughout all immigration courts where the same California drug statutes are at play. That's California Health and Safety Code Section 11379A and Section 11378. And really just anything that hinges on California's meth definition. The reason, Mr. Verdugo argued, and the court agreed, is because, quote, California's methamphetamine definition is overbroad, because it requires either that an analog be substantially similar in structure to methamphetamine or substantially similar in effect, end quote. Federal law, in contrast, requires both. What the heck does that mean? I'm no scientist, despite what you've heard, but I think that an analog is something close to meth that acts like meth and maybe smells like meth and is almost meth, but isn't meth. California and the federal government understandably want to criminalize both types of things, that is, meth and near meth. But under federal law, to qualify, the almost meth thing must be similar scientifically and in effect on the user. California to criminalize simply requires one of those things, either or, that is, that the analog meth be scientifically similar or have a similar effect on the user. That means that California criminalizes more conduct, right? Because the federal government requires both, and California only requires one. California is criminalizing more types of almost meth. This finding, this distinction between the state and the federal definition based on an analog, aligns with decisions out of the 4th, 7th, and 10th circuits, explains the federal district court. Should you find yourself in those circuits? Quote, the court accepts the prevailing view that the federal statute requires a showing of 2 elements, which is facially broader than the corresponding California statute that requires only a showing of one of those 2 elements, end quote. Emphasis by the me. What other state meth statutes are broader than this prevailing view of the federal meth definition? That's pretty much the end of it. As in the Ninth Circuit, like almost everywhere else, textual overbreadth wins the day under the categorical approach. All of this, by the way, despite the fact that the Ninth Circuit said precedentially in 2020, United States v. Rodriguez-Gamboa, that, quote, California's definition of methamphetamine is a categorical match to the definition under the Federal Controlled Substances Act, end quote. A bit overbroad of a sentence, the district court seems to be saying. That case, that is Rodriguez-Gamboa, was about methamphetamine isomers. This case is about analogs. Rodriguez-Gamboa didn't address analogs at all. Hence, it's not binding on the district court here, or the BIA, or IJs anywhere, etc., etc., etc. To paraphrase the district court, of course. Quote, cases are not precedential for propositions not considered, end quote, quoting the Ninth Circuit. And heck, I wonder what other drugs have analogs. A possible winning argument even when, like here, the circuit court doesn't believe that the overbroad isomer actually exists. I'm looking at you, 11th Circuit, and your pesky Shamu decision. Anyway, note this case, everybody. Sorry I waited this long to do it. But I'm busy, and it's not a published circuit win. I don't have to answer to you. I don't have to answer to anybody. And that is United States v. Verdugo. Are you struggling to find and hire new talent that you can trust? Does the idea of onboarding, training, and managing virtual staff overwhelm you? Staffy's got your back. Staffy provides top-quality virtual staffing for immigration law firms, complete with HR support to free up your time from the hassles of onboarding, managing, and continuously training your virtual staff. With an entire team of professionals, including psychologists and mindset, task, and performance coaches, Staffy ensures your virtual staff has all the tools needed to help your law firm grow and scale. Visit staffy.cc, that's stafi.cc, and schedule a consultation to claim $500 off your first month of service. Or, of course, click on the link in the show notes. Attention lawyers looking to dive into immigration law. Are you ready to master the art of marriage-based immigration? Introducing the Ultimate Marriage Green Card Course, a comprehensive resource by John Khosravi, founder of the Immigration Lawyer's Toolbox, to kickstart your journey in family-based immigration. His course offers 18 hours of engaging video content and includes monthly office hours for your questions. You'll analyze and learn, through the statutes, regulations, case law, and real-life practice, essential topics like 212 inadmissibility, 245 adjustment, consular processing, and the affidavit of support requirements. The course will also cover practical office procedures, consultations, and sales techniques. Plus, you'll receive helpful samples and templates to streamline your practice. As a limited-time special bonus, the Immigration Lawyer's Toolbox is adding the recordings of an all-day O1 seminar with the best O1 lawyers in Los Angeles. Go to immigrationlawyerstoolbox.com and click on the course link, or email John at info@immigrationlawyerstoolbox.com to sign up. Reference me, Kevin, or the Immigration Review Podcast and get an additional 10% off. Or, of course, click on the link in the show notes. Our final case is Sridej v. Blinken et al., published by the Ninth Circuit on July 23, 2024. As with all the cases this week, this one just interested me. I hope you agree. This case is about extradition. Miss Sridej is from the Kingdom of Thailand. They want her back to prosecute her and so formally requested her extradition from the United States where she currently is. That makes this whole case a federal court matter. This is not about removal proceedings. These are federal extradition proceedings. And that's because, kind of like the first Hague Convention case we did this episode, the United States and Thailand signed an extradition treaty on December 14th, 1983. The treaty went into force on May 17th, 1991. That is a long time between signing a treaty and it going into force. In Article 1 of that treaty, the parties, quote, agreed to extradite to each other persons found in the territory of one of the parties who has been charged with an extraditable offense by the judicial authority of the requesting state, end quote. But at the same time, the U.S. ratified the UN Convention Against Torture and implemented it in 1998. As we all know, you can't remove people to countries where they will more likely than not be tortured. Assuming all the other CAT elements met, of course. And that includes barring extradition. The CAT is very powerful when satisfied. It can even prevent the Department of State from doing something that the Department of State wants to do, which, as the Supreme Court showed us this year, is nearly impossible to achieve, ever. As to Ms. Sridej, well, quote, the Thai government alleges that from 2013 to 2015 she defrauded her employer by stealing electronics worth roughly $4 million, end quote. Looks like she fled to the U.S. right after her crime concluded, and a Thai court issued a warrant for her arrest shortly thereafter. In true American dream fashion, Ms. Sridej then, quote, moved to Las Vegas, Nevada, and began a new life, end quote. Lord knows how everybody found out, but in 2022, the Thai government officially made their request with the Department of State to extradite Ms. Sridej, which thereby kicked off federal court proceedings under 18 U.S.C. Section 3184. A magistrate judge certified Ms. Sridej's extradition. Apparently, that then allowed the Department of State the freedom to conclusively decide whether or not to extradite. That's the framework. In an effort to stop that, and again this is post-federal magistrate judge ruling that the Department of State can proceed, Ms. Sridej filed a writ of habeas corpus against the Department of State to prevent it from actually facilitating her extradition. A district court judge denied that. The Department of State then made their official extradition decision, and Ms. Sridej then appealed the denial of a habeas writ to the Ninth Circuit. That dispute in turn largely implicates the podcast's old friend, the Convention Against Torture. The Ninth Circuit affirmed the lower court and extradition. Under the Department of State's regulations, quote, where an extraditee raises torture allegations, the appropriate policy and legal offices review and analyze information relevant to the case in preparing a recommendation to the Secretary as to whether or not to sign the surrender warrant, end quote. Restated, the Department of State must make its Convention Against Torture decision before agreeing to extradite someone. And actually, it turns out that this matter is not so dissimilar from Munoz and the doctrine of consular non-reviewability. Even though Ms. Sridej is on U.S. soil, the Department of State enjoys immense power. Quote, under the rule of non-inquiry, it is the role of the Secretary of State, not the courts, to determine whether extradition should be denied on humanitarian grounds or on account of the treatment that the fugitive is likely to receive upon his return to the requesting state, end quote. All of these doctrines to allow the Department of State to really just do whatever it wants. Kind of made up by the courts. And it looks like the Ninth Circuit then takes the position that it cannot even review the no torture finding that the Department of State makes. So this case is actually about whether there's sufficient evidence that the Department of State made a CAT determination at all. They must under the regulations. It's procedural, kind of like Munoz, right? That's the only way around all these doctrines, even possibly. And in one Ninth Circuit case, the Department of State did lose because there wasn't evidence that the Department of State had actually made their no torture finding. An en banc decision, no less. Here in contrast, though, explained the court, the record has a declaration from an attorney advisor with the Department of State Office of Legal Advisor, promising the federal court, without further explanation, that, quote, as the official responsible for managing the department's responsibilities in this case, I confirm that the decision to surrender Ms. Sridej to Thailand complies with the United States obligations under the convention and its implementing statute and regulations, end quote. Ms. Sridej argued that not only was that declaration not signed by a high enough Department of State official to qualify, but it completely lacks case-specific information. The Ninth Circuit rejected both arguments. It is not in fact the case that a compliant declaration from the Department of State under such circumstances must be, quote, signed by the Secretary or a senior official properly designated by the Secretary, end quote. A quote that seems to have been made in the Ninth Circuit's prior decision on this matter, again en banc in Trinidad y Garcia v. Thomas, 2012. The declaration need not be from the official responsible for considering torture at all, which admittingly does appear to be the Secretary or a senior official. The Trinidad y Garcia quote is taken out of context, explained this panel. All that's required, explained the court, is, quote, competent evidence that the Secretary or a properly designated official made the determination required by CAT's implementing regulations, end quote. Then you can extradite. This legal advisor's letter suffices, particularly as he is the legal advisor who is apparently, quote, the official responsible for managing the department's responsibilities in this case, end quote. As to the allegation that the declaration says literally nothing about Ms. Sridej's torture claims, well, quote, the doctrine of separation of powers and the rule of non-inquiry block any inquiry into the substance of the Secretary's declaration, end quote. Emphasis by the court. Department of State, obtuse be thy name. Interesting case, though, if one that makes it practically impossible to stop extradition once decided. I suppose the extradition statutes make it such that the U.S. government need not institute removal or withholding only proceedings and can simply extradite Ms. Sridej? Because otherwise, of course, an IJ would very much need to explain his or her CAT reasoning. But the Department of State does not. But there you go. It appears Ms. Sridej is returning to Thailand. And that is Sridej v. Blinken et al. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.